Hi, my name is Barinada. I'm a startup legal expert and founder of Barinada Legal, a startup focused law firm based in Lagos, Nigeria. Today, I want to talk about a particular issue that has been on my mind for a while, especially as it relates to startup founders and equity split. Now, the law says that anyone who wants to do business in Nigeria must register their business in Nigeria. Prior to 2020, when the CAMA that we know, that's the Companies and Allied Matters Act, which is the principal law that regulates the formation and operation of businesses in Nigeria. Prior to the time it was repealed and amended in 2020, you could actually have some shares on reserve. In fact, the old law, which is CAMA 2004, clearly states that you must take up at least not less than 25% of the equity. That means that if you had a 1 million share capital company, you were under no obligation to share 50-50 equity at once. You were under no obligation to take up all of the shares. You could decide to take 25% of the shares and then warehouse or reserve 75% for other purposes that shares are normally used for in a company, right? Now, under the amended CAMA 2020, it now says that you must take up all the shares. Now, if you understand corporate law, if you understand the startup space, if you know and understand international best practices, you would realize that this is not such a good policy, especially because equity is something that denotes ownership in a company, and especially because this singular word, equity, has the capacity to generate investors and investments for the company. It has the capacity to, do so much, bring in talent to the company. So as a growing business, as a startup founder, it would have been in your best interest if you didn't take up all the shares at once. Now, here is what happens. Because the law says take up the entire shares 100%. So even if you have a 10 million share capital company, you must actually take off 10 million units of the shares at once. Ordinarily, taking up shares means that you actually paid for the shares, right? So when you have co-founders or you have people who say, I want to come into your business, the intention is that you're going to sell those shares. But what happens in actual practice is, because people want to comply with the regulation that says take up all the shares, what they do is they just split the shares randomly and say, okay, you know what, since we're co-founders, you take 50%, I take 50%. There is no consideration about who is bringing what value is this person bringing to the table, how much has this person paid. There are factors to consider before you issue equity. Now, because the law says take up the entire shares, there is that obligation, that compulsion to take up everything without minding these factors that I just mentioned. And now that could really be fatal. How? Take, for example, you now co-found a startup with someone, a scalable startup, right? And then 6 months down the line, or even a few months down the line, this person that you brought on board as a co-founder or you issued shares to, gave like as much as 40% and you had 60%, this person is underperforming, this person is no longer pulling in his weight. In fact, this person is basically not interested in the startup anymore. But guess what? He still has his 40%. And so he suddenly stops, being interested in your business. And so every time you want to do something, and because you've also used him as a signatory to the account, because you must provide to if you're two directors and all, he's not forthcoming. You need to sign some documents. He's not there to authenticate those transactions. You need to make withdrawals from the bank. He's unable to, make himself available to do all of that with you. You're frustrated. So it almost feels like he's holding the company hostage. And then you approach him and say, you know what, since you're no longer a part of this company, please, can I have the shares back? And he says things like, no, you have to buy the shares from me. And then there is an actual investor who is interested, but then again, you've taken up all the shares. You don't have any further equity to give to this person, to this investor who wants to put in money into your business to actually scale or grow your business. So you approach this person again and say, you know what, I have an investor that wants to come in. Please release some of these shares so I can give to him. And the person says, oh, so if you're ready to now raise funds, please buy back my shares. I am not giving it to you for free. You need to buy back my shares. So what he's basically doing is holding the company hostage. And this is simply because the law permits that. It permits that when by saying that you could take up all you must take up all the shares. Imagine if it was a situation where you could only take up 25% of the shares and warehouse the remaining shares. It means that if you're not sure about the person, you will not give as much as 40% to the person as a co-founder, right? It means that you will gradually issue your equity. It means that you can say, you know what, for 5% equity in my business, I can raise XYZ amount of money. But no, you've done Father Christmas with the shares because the law says take up all the shares. So the dilemma that you would have is, how do I properly warehouse some shares, even though we're two co-founders? But then again, you know that, okay, I have plans to, raise investments, raise fundings from investors in the future. I have plans to use some equity as option pool, bring in the talents that we want, bring in the consultants that we want. I have plans to do employee compensation, stock option and all of that. So the question will be, how do I keep this fraction of the shares, being that the law says take up everything? One way to do that is, number one, one of the founders I met earlier last week, what he did was to give the equity, the bulk of the equity, right, to his younger brother. And that meant that on paper, the younger brother was a majority shareholder. Even though the younger brother has no relationship with the company at all, he's not a party to the formation of the contract of the company. But because he needed to solve that dilemma of taking up all the shares, he took the shares and gave to his younger brother, and he himself had a lesser share, being the founder and the CEO, and his co-founder also had a lesser share. So someone who is not even a part of the company has so much. And then that was that. There was no further documentation, there was no further communication as to, okay, this is how much I'm giving you, but you're holding this business in this shares interest for the company. Now that's the wrong way to go about it. What you want to do is, since you're the CEO, you need to have an understanding with your co-founder. You need to have an understanding with those who you're forming the company with, right? See, you have to find a way, one way or the other. If the law says don't do this, find a way to do it while not still breaking the law. And so what do? You could put on paper, like document everything in black and white, have a board resolution that XYZ amount of shares has been given to this person to hold interest for the company. And that means that whenever the company has need for such shares, the person would willingly relinquish the shares to be used for that purpose, because the person knows that this extra shares that I'm being given is not mine, right? So it's safer to do that, or to hold that when you are the CEO, when you are the founder. And then, but before you do that, you must ensure that there is a documentation, there is a contract, there is an agreement in addition to your board resolution, stating all the conditions that must be present, or that guides that extra shares that is being transferred to your name. Because don't forget, you have to also do post-incorporation filings with the CAC. So whenever the need arises, there has to be documentation for that purpose. So that's the correct way to warehouse extra shares now, in view of the fact that the law says take up all of the shares. So if you go ahead and just carry your equity and give to someone and say, please hold it for us, it's like carrying your property and saying, please let me hold this thing, when I come, anytime I need it, you give it to me. But there is no contracts, there is no paperwork, there is no documentation stating that this was the understanding you had. You just gave in your properties. You could as well turn around and say, you know what, I am the real owner of this property, because guess what, there is nothing to show that you are giving out that equity in trust. There was nothing to show that you only wanted him to have that equity just for the purpose of, warehousing it for the company. So he will come around and say, you know what, if you want my equity back, then you have to buy it back. Again, the company is being held hostage. So I advise startups and people who are going into business for the first time to please work with a startup lawyer. A startup lawyer knows exactly what to do, what kind of clauses to put, what kind of agreements to put in place in order to protect your interest as a business owner. See, running a business in Nigeria is a very tough one. Running a business that is highly regulated is a very tough one. So you want to be sure that you're protected every step of the way. So if you are in a company or you've co-founded a startup with people and you supposedly have some shares on reserve with someone, even with a co-founder, but these documentations are not in place, these key clauses and terms that I just mentioned are not in place, what you want to do is to go back and revisit. And this is what we do for startups. First of all, when we come into your business, the first thing we do is to do like a reevaluation of your existing documents, do a revamp, do a restructuring, you know, make amendments where we think should be made, okay, and then get you started off on the right path. So if you're looking for a startup lawyer or a startup law firm to work with for your business, for your startup, please do not look for that. Simply comment or simply let me know in the comment section or send me a DM, and then we'll get it started. We'll take it up from there. Thank you, and I hope this was helpful.